if you post it on the outside of the front door and mail it, it's effective that day because the posting in person is considered you got notice now.
Over is the primary reason. The monthly rent was $800. So prorated to today is $2,141.93.
I'm sorry, Mr. Kahan, real quick. I'm trying to
Yep.
type and
Sorry,
listen. $800 or 1,800?
800. It's
Eight.
so this was the owner lives in the unit, so she rents a room.
Okay. All right. Go ahead. Any portion from the government?
No,
All right. Was this a CARES Act property?
property is CARES Act, but via the termination notice, CARES Act doesn't require the 30-day notice once the lease is terminated.
Oh, so y'all proceeded under the holdover.
Yeah.
Okay. What day was the notice to vacate for holdover given?
No, was November 29th.
November 29th?
That's correct.
Okay. All right. And then the notice of termination was provided when?
October 17th.
Okay. Was there a written lease between the parties?
Not per se. This was one of those Roomster he listed at $800. So that's what we have as our Exhibit A. That was what was listed in the agreement. That the terms were then verbal from that, but just to document that there was something.
All right. So this is the initial one. It was going to be $800 per month.
That's correct.
All right. And then the notice of termination here was going to be through the end of the month, the following month.
No, so it was it's a 1 month termination notice. So under um, Property Code 91, it has to be equivalent to one. It doesn't have to be one full one. So we did, in this case, it was a 31-day termination. So he could have given the notice to vacate on November 18th, but he was out of town, didn't want to do that when he wasn't around.
All right. So you sent this, and rather than give her to the end of the month, you're giving her just a flat 30 days.
31 days in this
31
case.
days.
Yeah.
And that's per
Texas Property Code 91. I can pull up the wording if you.
all right. I see that 9101B. All right. All right. And then after the deadline given in the notice to vacate, did the defendant move out?
Did not.
All right. So they were still there after October 17th. All right.
That's
And then the
correct.
notice to vacate was then sent again. Well, first, there was a notice of termination saying we no longer wish to have a lease. And when they didn't move out, November 29th is the 3-day notice. And so here is that. And what was the method for this one, Mr. Kahan?
Both of them were done by posting on the inside of the entry door by the owner himself, who is, I believe, here. And we also mailed. So we mailed it a day or two before he posted it, so it should have all gotten there at the same time. But we're relying on the posting. Posted on the inside of every entry door, so we don't have any argument about which one is the entry door.
Oh, okay. All right. All right. Good morning. Thank you for your patience, Ms. Rashida.
Good morning, Your Honor. Thank you. No worries. Can you
All
hear
right.
me?
Yes, I can. Thank you. Mr. Cahan's counsel, he's here on behalf of the landlord, Mr. Hudsky, and he's given me some information here, and he's given me some paperwork to kind of show me that history took place. Well, let me just ask you a few questions and confirm some things, and then give you a chance to answer, give me any information, and ask any questions as well. Okay. All right. The first thing he said is that there is a lease between the parties, but it is a monthly rent for a room within a larger unit, and that under that lease, it would be $800 monthly rent. Is that correct?
Or lease, correct.
Okay. And that they sent you a notice to terminate, saying that they wish to end, or that the landlord wished to terminate the lease. And they sent you that notice in October, on October 16th, and gave you 30 days. Do you remember receiving that letter?
Yes.
Okay. They said that you did not move out, and that because you have not moved out, they gave you a new notice to vacate, saying, if you really don't leave, we're going to move forward with an eviction. That they posted that to you on November 29th.
They put the outside of the door yet. Correct.
When you say outside of the door,
Outside of my bedroom door. Outside of outside of my bedroom door, and then the plaintiff, the landlord, posted the notice from the 29th on every single doors of the house,
okay,
and then outside of my bedroom door.
okay, all right. Well,
And sorry, go ahead.
no, I'm not trying to interrupt you, Miss Rashida.
Oh, sorry, I didn't mean to interrupt you either. So, and then the certified mail that is sent, which was received, I believe, on the 6th, that one was not delivered. The defendant, with the never-ending cycle of harassment, he posted it on my car. Basically, that's how he delivered that notice. He's posted it on the windshield of my car.
Because y'all both live at the house where the letter was coming.
Correct. But
Got
I
it.
don't have a key to the mailbox. He refused when I moved here and I paid rent. He refused to give me a key to the mailbox, so I don't have a key to receive mail. I don't even receive mail here. So he's the only one who has a key, and he refused to give me a key. So he picked up the certified mail at his mailbox, and then he posted it on my windshield on the car. Yes,
All
it's
right,
not.
that's an interesting. Huh. I just be aware, if you're ever renting again and the landlord's refusing to give you a key, there's ways to go about seeking a key directly from the mail, the postal service, without having to go
Oh,
through the landlord.
really?
Mm-hmm.
I didn't know that. Okay, thank you.
I've encountered this situation. It's not common, but it's not rare.
Okay,
There are ways to go about that. So I would say
thank you.
those legal aid resources, if you should ever encounter that situation again, contact them and they can tell you exactly how to do it. You can also just call the postal service, go to the local postal service company,
Mhm.
and say, hey, I need to get a key to the mailbox. What do I do? And then they've got some
Oh,
instructions about how to have that happen.
okay. Thank you so
Okay.
much, Yon. I wasn't actually aware of that. He didn't give me a key to the mailbox, and he didn't give me, refused to give me a physical key to the house. So I was renting here, paying rent for 2 months on time every month, and he didn't give me a key to the house. He gave me digital access, which you can take and, grant and remove anytime you want. But he refused to give me a key to the house. So I was living here, I didn't have a key to the house.
Okay.
Didn't have a key to the house, didn't have a key to the mailbox, didn't have a lock on my bedroom door, which all were promised before I actually entered into a lease with them.
Yeah,
Yes, that's
yeah,
what I've
that's
been
just
going
okay.
through.
All right. All right. Ms. Rashida, are you currently still living in the bedroom?
Correct. Yes, ma'am.
Okay. Is there a lock on the bedroom door?
Now there is, after he tried to hit me and lunge at me and tried to hit me when I insisted, the day that October 1st, I asked him to, if I'm going to continue to stay here, pay rent, I need a key, physical key to the house, and I need you to put a lock on my door. That's when everything started. Instead of giving me the key, it was retaliation and giving me 30-day notice. He lunged at me, tried to hit me, and I filed police reports for that. So
We do object to, first of all, not relevant, but also dispute statements, including the key to the mailbox, which was offered to her and she refused it. So, not relevant. We would like to object to that.
it is relevant. The owner, the judge asked me a question, so I'm just answering the question that she asked me. This is very relevant.
I hear a lot of things in that.
Mhm.
And what I would say is, Miss Rashida, if you find yourself in a renting situation where you're encountering issues with locks or with mailbox keys, immediately seek assistance from renter protection groups. Okay.
Got it.
That is not a defense though to a holdover termination or to a non-payment case. You may have a cause of action before any of that happens, and you certainly have rights to receive some of those things under a lease. But the reason the plaintiff is saying that they have the right to have you move out with an eviction is that they told you they no longer wanted you to be a tenant. And it may be that you no longer wanted to be a tenant as well. But once you've been given notice and time has been provided to you to move, if you don't move, then the law does consider that to be a holdover. Okay. And so under that, based on everyone's testimony, I hear that that is an accurate situation, that indeed you were told we no longer want to rent to you, and you have not been able to move out, and as a result, you would be deemed a holdover at that point. Now, Ms. Rashida, he also indicated that rent wasn't paid in full for October, December, and now October, November, and December. Ms. Rashida, did you pay rent in October when you moved in?
I moved in August. I did pay 2 months of rent, but October, November, December, no.
Okay, so those rents remain unpaid then?
Correct.
Okay. All right. Well, with that information, the plaintiff has met their burden to show it, and I do see the notice to vacate here is proper. They did give you a sufficient time on the notice of termination per the property code. So all those things are right. And then notice to vacate is for 3 days. He did post on the inside of the door, so it's effective at that moment.
No, when you say inside of the door, I'm kind of confused.
If you put it on the inside of the front door to the whole unit, that's sufficient. And what you said is that he did. He put it on the inside of all the doors, but on the outside of your bedroom door.
Correct.
Putting on the inside of the main door would be sufficient because you're renting a bedroom and you have common space area. So when you came into the unit, the distinction between the inner and the out of the door is to make sure that if they put it on a public outer door, like in an apartment complex or on the front of a house, your neighbors walking by don't see private information. Here, they put it on the inside of the door and then on the outside of your personal bedroom door inside the house. But the ones on the other doors would be sufficient. So that does count.
Got it.
That's a good question, because that distinction comes up, especially when we get more and more renting by the bedroom situations. You know, where is that door line? And typically it's considered what is freely accessible to the public versus that which requires like a key, like you had to get inside the house and then it was posted inside. So, okay. All right.
So the certified, quick question, the certified mail, is it proper notice to put certified mail on someone's windshield as proper notice?
No, but I don't find that one was proper. It's the one that he posted inside the house. That one counts. So he sent you the same notice 2 different ways. But no, if you're unable to get mailbox, now again, there's some dispute about whether you could have gotten a mailbox key or not. The court doesn't have to worry about whether that is a valid form, because the one he posted on the inside of the front, the living room door or the main door, that one is sufficient per the statute.
Got it.
Okay.
Understood.
For certified mail, as long as you're available to get the mail, if you never receive it, the landlord, it still counts so long as they can prove to me that they sent it and they gave you the right timeline in it. That if that is the only way he'd sent it, then there would be a question of fact, and I would have to hear from both parties about, did you have a key? Did you have an app as to get to it? But the fact that he posted on the inside of the house, that one is sufficient for the notice. All right. Well, Mr. Cahan, so we have the 3 months of rent and then court cost. Are you seeking any amount for attorney's fees? Is there a contract towards that?
There's not. That's where I was going. No, we're not seeing.
Okay. All right, then. October, November, and December. I will prorate the rent. I'm just kind of in a mood today. So the amount of back rent is going to be $21.42.01. And I'm going to set the appeal bond, though, at twice the monthly rent. So the appeal bond would be $1,600. And then, Mr. Kay, and I know you're counsel, so you can explain that to your client. But Ms. Rashida, what that means is that if you wish to appeal the decision of the court, and you absolutely can, there are 2 numbers that you would see on the final order. One of the numbers is the appeal bond, which is $1,600. The appeal bond, it may be that you don't have that, and you might qualify for what's known as the affidavit of inability. But because there is a non-payment and a holdover case, you might be having to pay a full month of rent in order to stay in the property if indeed you appealed. Okay. To really understand your options and your rights, please contact any and all of those legal aid providers. But you have at least 5 days beginning tomorrow to seek an appeal or to take steps further. Otherwise, At the end of that time period, when the court reopens, the landlord can seek a writ of possession if you haven't already moved out. Okay.
Okay.
All right. Any questions I can answer before we release the parties?
Yes, Your Honor, you did mention at the beginning of the hearing that you're going to be off all next week, and I'm assuming you're coming back on the 2nd. So if there's going to be an appeal, I know that you said no legal advice, but I want to know when you guys are coming back. Or
Our
when
court will reopen. Our lobby will be back on the 3rd.
on the 3rd. Okay, but
Okay,
if there's
because
an
the
appeal,
1st and the 2nd are county holidays.
okay.
But the 3rd is not necessarily the final date of your appeal. It's just the day our court reopens. To
Mhm.
truly understand what day you have, please call legal aid. You have at least 5 days, and that 5 days begins tomorrow.
Okay,
All right.
understood. Understood. So regardless of when I know you close, we can still file the appeal. And
Absolutely. And if
all
you
of that.
need to come in person, let our court know, email us, call us, and we can make arrangements to meet with you. You could also
Okay.
file things online. Okay.
Okay, so if you off all next week, do you still receive calls? Is there
Yeah.
someone that
Our front lobby isn't open, but the
Okay.
court is open. We'll be answering the phone,
Oh,
answering
okay.
emails. We'll be doing e-file. The only thing we can't staff is a front desk. We've got very limited staff, and it's a holiday week, and it is what it is. So everyone's
Understood.
working remotely next week. So that's just
Understood.
we just
Thank you,
want to
Honor.
give people that knowledge. But no, that's good. We're open. We just don't have a front lobby. So
Got
imagine
it.
rural counties, they've got 2 people that work for the whole building, but the court is still open. It's just we don't have a public lobby space. So that's a distinction. All right.
Understood.
Please as well, agents, you can e-file all day long, and we'll be accepting and processing those just like normal.
Okay.
All right.
Understood. Thank you so much, Your Honor. Thank you for
Thank
being
you very
fair.
much. Good luck to you, Ms. Rashida. Enjoy the holidays until this all
Thank
comes
you.
to its conclusion. Mr. Cahan, you as well. Any other matters with us?
Nothing further. Have a good rest of the year, and I have a feeling that Miss Sterling's next, so good luck to her as well.
All right. Thank you, Mr. Cahan. Enjoy the holiday season. All
Thank you.
parties for that matter are excused.